Well, thanks very much, Tasha, and lovely to be back. And thank you again for inviting me to speak. Last time I talked about rights of disabled children and the specifics, the assessment process. And in this session, I'm going to be talking about services, support services. The discussion hopefully will range across all the services, although a number of the points that have been raised previously concern direct payments and personal budgets. So I might spend a bit more time on that. But as Tasha's just said, I'll speak for about an hour, I think. I may skip over the slides quite quickly towards the end. So we'll then have a break for about 15 minutes, hopefully about 11:15. And then the remainder of the session, we'll have discussion, and colleagues will have sort of put the questions in the chat bar into themes, hopefully, and I'll respond to those. So I'll just put the screen share up, and hopefully you can now just see the slide which says care and support services and my name. And for those of you who weren't on the last session, I'm an academic. I've been a solicitor for about 40 years, but I've just recently stopped that. And now I just focus on my research work. I'm a professor of the Cerebra Professor of Law and Social Justice at the School of Law at Leeds University. My chair is funded by Cerebra. It is a disabled children's charity. And our work is on problem solving, common problems that parents of disabled children encounter. And I've just circled there the website I have. Hopefully that's just come up as a circle and you can see it. And if you go onto that, it opens up various web pages, which are quite useful ports of call if you have difficulties. The whole site's free to access. There's no signing up or anything like that. So on the resources tab, which I've opened up there, you'll see that I have a note that on challenging reductions in care, challenging demands to repay direct payments, personal budgets, things like that, which hopefully will be useful. On the left-hand side, there are various other issues, lectures, and so on. If you click on the publications tab, you can download most of the books that I produce free of charge. Not all of them, though. So yes, there's one called Carers and Their Rights, which it's 2018, but the law hasn't changed since then. That was the 7th edition. It's 100 or so pages. You can just download that. Disabled Children, a Legal Handbook. That's a biggish book, 600 or so pages long, but that's free to download as well. And that's got chapters on services and education and social care and healthcare and transitions and so on. I think I'll be referring to the Accessing Public Services Toolkit quite a bit in this session or in the discussion. It's only about 35, 36 pages long, but it's full of information about how you do challenge decisions you think are unfair or unlawful. And it's got precedent template letters at the end. And it's been downloaded, I think, 60,000 times. So I think it is reasonably useful. It's free, obviously. And then there's a big beastly book I write on social care for adults, people 18 or over. That's not free. It's over 1,000 pages long, but that's something you can borrow from the library. It's got the wicked detail on the whole range of issues you're likely to encounter. So a big chapter on direct payments, big chapters on services and stuff like that. So I've also done a PowerPoint for today, handout, which you hopefully will have access to if you haven't already had it. I've moved a couple of the early slides around. So if you have got a copy of it and you're looking at it, the slides that you'll see are there, but I've moved some of them around just to be irritating. I'm sorry. So what I want to talk about is you know, the sort of substance of care and support services, what they're supposed to look like, what range of supports are available. In the last session, there was some discussion about funding panels. So I put some new slides in there. Then I was going to look at personal budgets, direct payments, and a problem that's been mentioned a lot by in the first session and your colleagues, but it's also a wider English problem, and that is really a lack of suitable PAs, etc., to use direct payments to purchase, or even if the council's commissioning the service, a lack of suitable personal assistance. So to kick off with a sort of general overview of what sort of care and support services should local authorities provide. And the answer is, under the social care legislation, they've got to provide pretty well anything that falls within the definition of social care. So that won't include educational supports, and it won't include sort of specific health supports or housing necessarily, although the accommodation in care homes and supported housing is covered. And so when we're talking about people under 18, legally referred to as children, we're talking about services under the Children Act and a thing called the Chronically Sick and Disabled Persons Act. And you don't need to really get your head around the differences between those two acts for the purposes of social care. Effectively, the Chronically Sick and Disabled Persons Act is being absorbed into the Children Act. It's a curious relationship. As many of you will know, if you're seeking an education healthcare plan, health and care plan, you do need to separate out services under those two acts, but for general purposes, you don't need to worry about the differences. And though these between the two acts, they say that once a local authority has decided you need something, they've got to do this. And that could be personal care in the home or in the community. Or, I mean, I work at a university. Many of our students have disabilities. Some of them have personal assistance and so on. And often those personal assistants are for social care reasons rather than education reasons. And so those will be funded if they're under 18 under the the Chronically Sick and Disabled Persons Act. If they're over 18, they're adults and they'll be covered under a thing called the Care Act, which we'll look at in a minute. So personal care in the home or in the community and an activity, community-based recreational services, respite, short break, replacement care, it's now often called, direct payments, adaptations, equipment, fixtures, fittings, that sort of stuff, travel to community-based services. And so that's the sort of range. And during the chat, if there's any, during the discussion, if there's any issues on any of those services, put it in the chat and we'll try and deal with that, those questions, those comments after I've done this talk. The one thing about children's services is there's no duty to have what's called a personal budget. I'll look at personal budgets in a minute, but the law only says that you've got to have a personal budget if you're 18 or over and eligible for support. So if you're an adult, then there's a very similar range of services, but you get these under a different act, the Care Act. And the only real big difference between those two services I've just said is that councils have got to give you a personal budget if you're an adult. And I should say, I think personal budgets are a waste of space, and I'll make that point in a minute. I think it's a bureaucratic exercise. So the fact that only adults have to have them doesn't mean that children services are any worse off. Now, running through this is the idea that once a local authority has decided you have a need for support services through the assessment process, which is something we looked at on the last session, they've got to meet that need. It's what's called a non-resource dependent need. It means that they can't say, well, you do need 10 hours respite care, but we haven't got enough money, so we're only going to give you 5 hours or 6 hours or 7 hours. Or they can't say, well, I know you got you were assessed as needing 8 hours last year, but we've had a funding crisis, so we're only going to give you 4 hours this year. You can't do that. You've got to meet need regardless of resources. And that's what I say there. And that was held in a case many years ago against Islington. And so you can't have maximum packages. You know, whatever you need, the local authority's got to provide it. If it's got two ways of meeting that need, it can choose the less expensive one. But if there's only one and it costs £5,000 a week, then it costs £5,000 a week. And you get this sort of nonsense of sometimes councils saying, well, you know, you've got a very big package, as if somehow you're being greedy. And the answer is, well, if you need a big package because your impairments have significant impact on you and the family, then you need a big impact. It's not like a big package. That's what the welfare state is available for. It's there to help those with the most needs, with the most support. That sort of value judgments are really unhelpful. And under the Care Act guidance, this is paragraph 1027, it's expressed very well. It says a local authority's finances are relevant when it decides how to meet a need, but not whether to meet the need. The need has to be met, but if, as I say, there were two ways of meeting the need, and one is less expensive, the local authority can choose that. But the local authority shouldn't set arbitrary upper limits on the cost they're willing to pay. And we'll come through with that as I discuss direct payments, because I think one of the themes that came out of research that we did a few years ago at Leeds is that the direct payment rates, hourly rates, are so low that they almost sort of appear to be fixed, like you can only get £12 an hour or something like that, which isn't true, but that's, again, a local authority setting an arbitrary limit, particularly when evidence seems to suggest in much of England these rates are much too low to attract and retain sufficiently skilled care assistants. And you get this sort of weird phenomenon of funding panels. It came up at the, as I said, at the last session, so I've put a couple of slides onto this. But on my resources tab of my website, which we looked at the outset, I have a note about funding panels, which is very detailed. So this is just a brief summary. But if you want more about funding panels, go to my website or the problem solving toolkit, the Accessing Public Services Toolkit's got a page. Actually, it's got this image on it of a funding panel meeting. So the phenomenon of funding panels is it can be summed up by a social worker or a care assessor. It doesn't have to be a social worker. A care assessor comes and assesses what the disabled person needs. They sit in the house, they see the person, they talk to them, and they apply some professional judgment to that. And it's often said about 75% of all the information we take in, most people take in, is visual. So they use all their senses. They then write up their assessment and say, for example, I think Fred needs 8 hours respite care a week or something like that, or 12 hours personal assistant care each week. And then they say, well, yes, we accept, they say to the family, yeah, you quite clearly need that, but I don't decide. It has to go to a funding panel. They're not normally called funding panels. They're normally called health quality control panels or love and happiness panels. They've got a disguised name, but effectively their role is to ration services, and there'll be senior officers, not all of them social care experts. Sometimes there'll be sort of finance people. And it goes to the panel, and the panel then says, no, we can't, this is too generous. Instead of giving 8 hours respite care, we think it should be 4, or instead of being 12 hours personal assistance, we think it should be 8 or something like that. And then the individual's told that unfortunately the funding panel, or whatever the panel's called, has made this decision. And legally, judges and ombudsmen have a real problem with these panels because the whole point about an assessment is it's a personalized process where somebody with the relevant skills, the assessor, uses their professional judgment, looks at all the facts, weighs all the matters up, and comes to a decision. And the question is, what is the information the panel's got that the assessor didn't have? The panel hasn't seen the person. Probably the panel doesn't know the person. The panel didn't sit with them, didn't take in that information. What professional judgment has the panel got that gives them the right to overrule what the assessor, who was there and took that all in, decided? And so very, very frequently, ombudsmen and courts strike down panel decisions and say, well, these are just arbitrary rationing decisions, not based on need, but based on finances. And you can't make decisions in social care based on finances. The Care Act, which is, panels are for disabled children and disabled adults. They seem to exist for them both. The Care Act, which is for adults, gives very good guidance on this, I think, and it's equally applicable to children's services. It says this: in some cases, panels may be an appropriate governance mechanism to sign off large or unique allocations or plans. Where used, panels should be appropriately skilled and trained, and local authorities should refrain from creating or using panels that seek to amend planning decisions, micromanage the planning process, or in place purely for financial reasons. I think that's good advice. If you're going to be spending £4,000 a week on it, or £3,000 a week on a particular individual, I think there is a need for senior expert, skilled and trained panel to look at this and see if there's another way of using the money more effectively. But what we're hearing really is that panels aren't used for large or unique allocations. They're used for everything, basically. Everything pretty well goes to panels, and they are micromanaging and amending planning decisions, and they are put in place purely for financial reasons. So panel decisions should be challenged, and you should be able to get all the data of what the assessor recommended and who was on the panel and their reasons for disagreeing with the assessor if they do. And I've given you some notes there. I'm not going to go through those in great detail, but there's some panel decisions the ombudsman's made. The other thing I wanted to say as sort of preliminary is that very often if the local authority decides that you or your disabled child have a need, they will commission the service, or they will encourage you to have a direct payment. If they commission the service, nearly always that service will be privately provided. The days of local authorities having in-house services in much of England have gone. I don't know whether Hull still does, but in most parts of England, the services will be provided by a private company, private organisation, not the council. And what the Ombudsman said is that that's fine, but if something goes wrong with that service, you don't complain to the private company, you complain to the council. Councils can't contract out responsibility for services when they contract out the provision. Poor quality care by a council funded provider is poor quality care by the council itself. And that's a fairly important point about knowing that they'll say, well, you should complain to the provider, and you just, I think, quote what the Ombudsman said. No, it's your responsibility. And if there's a problem with the quality of the provider, you ought to know about that. And that's why I'm complaining to you. You sort it out. You arrange for them, not me. Okay. So I'm just going to go and talk through personal budgets and then direct payments, and then a couple of other points. And then at about 11-ish, we'll break for 10, 15 minutes and then have an open discussion. As I've already said, I'm not a fan of personal budgets. They came in with the CARE Act, which makes it mandatory so that everyone who has support from a local authority must have a personal budget. So what's a personal budget? And what I'm trying to do here is to distinguish between personal budgets, which I think are really problematical, and direct payments, which I think, you know, can be a very good idea in some cases. So a personal budget is effectively where the council gives some money, but not to the individual. If they give the money to an individual, that's a direct payment. The idea, and all direct payments are personal budgets, but a personal, I mean, where the council gives money to an individual, they call it a personal budget, but it's actually at law a direct payment. A personal budget is which isn't money going into the bank account of the individual, is a creature that's rather different. So effectively, the council pays the money to a care provider. And the care provider then employs people to provide services to the disabled person. So this is actually just the council commissioning services from an independent person. The thing about this is that the council tells you how much they're paying the care provider. You know exactly what the service costs, but you don't actually get that money in your bank account. If you do get that money in the bank account and you yourself employ a PA, then that's a direct payment. So about 15% of all people get a direct payment. So those 15% need to know how much money they're going to get, because they need to know how much they're going to pay their employee or whatever. The other 85% of people, particularly older people, don't get the money. They just get a service that's commissioned by the council. But the council's got to tell them in addition how much that costs the council. And therefore, that's what they're told. They're said, you've got a personal budget of £100 a week, and it's and we are using this to employ this agency. So they tell you what your support services cost. And that is what a personal budget is. And a personal budget must always be sufficient to meet the person's care and support needs. Now, why does the council tell you what it's going to have, how much it's spending on your behalf? Why is that of interest to you if you're not getting a direct payment? I mean, we don't do it in anything else. If you go into hospital and have a heart operation, they don't tell you what the heart operation costs the NHS. And if it did, you probably have another heart attack, because it will be a huge sum of money. why does the government want everybody who gets support from local authorities to be told what that costs? And I think it's a very sinister reason. In reality, it changes the way people talk about care and support. Instead of care and support being a personalized, empathetic support arrangement, which is really of fundamental importance to all humanity, it becomes a commodity, a sum of money. We don't talk about your care and your needs. We talk about your budget, as if you can reduce everything that is done to you is in financial terms. It's what's called commodification. And one shouldn't really change one's language too much to talk about my budget. It's about my care needs, my child's care needs. It's not their budget. It's much more, you can't just quantify that. It's a quality thing as well. But the law says you must be told what the support costs are. And if the local authority says, well, the whole budget is £100, we're putting in 80 and you've got to pay 20, a contribution of 20. And this is for adults. And it must be transparent. You must know exactly how this budget has been calculated. You need 10 hours a week personal assistance. The rate we're giving you that is £12 an hour. So your personal budget is £120. And if you're an adult, we think that you should be contributing 30. So we're putting in 90 and you're putting in 30 and the budget is 120. And in a Court of Appeal case against North East Lincolnshire, the court said that that's got to be transparent. The individual's got to know precisely how this figure was calculated. Yeah, that's all I'm saying. Why do you need to know this? If you want a direct payment, yes, you need to know it, because that's how much you are actually going to have in your account. If you don't have a direct payment, you just have this notional personal budget, then all you're interested in is making sure that you get what you need in terms of quality and quantity. Just to give you an example of a case on a personal budget, but this was one that actually, so this is a profoundly disabled adult, and she was cared for by her mother, and her mother had her own health problems. And the disabled adult had eligible care needs in 9 out of 10 outcomes, which means that she was a profoundly disabled person. And she was cared for at home. And in fact, she couldn't go into a residential respite care home at all. She couldn't have, when she had respite care, when the mother needed a break, she had to remain at home. And so additional care support had to go in to replace the care that the mother was providing. And it was assessed that she needed 6 hours, sorry, I can't see that. I think it was 6 weeks respite care a week. Now, during the 46 weeks a year when the mother was providing the care with support from other people, the disabled adult received a direct payment of £849.57 a week. So during the vast bulk of the year, except when the mother was away on having a break, the disabled adult got support from the mother plus a direct payment of £849.57 a week. Now we need to know how that, because that direct payment is actually a personal budget as well, but it's a personal budget paid to the individual. We need to know very precisely how that's calculated. And the local authority did that. They provided a very good, pretty good explanation. This is how many hours at this rate, and this is how many hours at that rate. These are double-handed rates, and so on. And so it did provide a very clear statement as to how that sum was calculated during 46 weeks of the year when the additional support was being put in unpaid by the mother. But as we've just heard, for 6 weeks of the year, the mother needed a break. So during those 6 weeks, you'd have to have that amount plus the additional cost of somebody replacing the mother. And the local authority said that during those 6 weeks, when the mother wasn't there, they would pay their respite care break, which was £659 a week. Now, you don't need to be a genius to realize that that's nonsensical, because if the normal rate was £849.57 with input unpaid by the mother, then when the mother's not there, the rate will have to be £849.57 plus the additional cost to replace the mother. But somehow the local authority said, oh no, because we've got a standard respite care rate, and that's what it is. And of course, that's nonsense. And the Ombudsman said that's nonsense. You can't have a one-size-fits-all for respite care. In this case, it's going to have to be much more than your standard rate, which was based on a care home rate. Each budget must be calculated according to individual needs, not to standardized formula. That's right. So that's that. Direct payments is where you have a personal budget, but instead of it going to being used to pay third parties like independent sector, it actually goes into the bank account of the disabled person. That's what the whole point about direct payments are, is that it gives the individual, in theory, choice. We're seeing a move, I may discuss this with councils, to try and sort of have some hybrid arrangement called prepayment cards. But the guidance says that everybody who wants a direct payment can have a traditional direct payment, which involves money going into their account. The law concerning direct payments for disabled children comes from the Children Act, section 17A, and there's fairly old guidance and regulations on that, 2009 guidance. And for adults, it comes from the Care Act, and there's statutory guidance. And I'll be in these PowerPoints, I'll be referring to the guidance between the guidance for disabled children and adults is the same, so that they can read across. The Children Act guidance is sometimes much more exhaustive, much fuller. But you could say, well, since the law is the same, we'll use the Children Act guidance to explain what should happen in this case for an adult, because the adult guidance is incomplete. The whole point about direct payments is choice. And choice goes to the heart of it. You only take a direct payment if you want one. But increasingly, councils are saying, well, you're going to have a direct payment because we don't provide this service, or we don't provide that service. What you want is a bit awkward, which is a bit unusual. We're not going to provide that. You'll have to have a direct payment for that. Well, that's just nonsense. The councils have got a duty to meet need, and you only have a direct payment if you want it. But increasingly, people are having it because they feel they don't have any choice, because if they don't take a direct payment, they'll get no service or a substandard service, and that should happen. Again, that's an ombudsman's case against Lincolnshire. You can't force people to have one rather than directly commission the care. If you're a disabled adult and you lack the ability to manage your direct payment, then it can be paid to an authorized person. And that could be a lasting power of attorney or court of protection deputy, but it's anyone that the local authority considers to be suitable. And somebody that will act in relation to the disabled adult's best interests. For children, it doesn't matter because normally the direct payment for all disabled children can be paid to the parents. There's a duty to offer a direct payment, providing it isn't residential care. There's a general exclusion of getting a direct payment if you're going into long stay residential care. So once you've been held to be eligible for some form of support, providing it isn't long-term residential care, then the local authority must say you have a right to have this under the direct payments arrangements if you want, but you don't have to. We've got cases where local authorities are very resistant to offering a direct payment for certain services, such as block-funded respite care. So the local authority might say, well, if you need respite care, we've already got an allocation with this provider, so you can't have a direct payment because we've block-funded respite care from this provision, and that's not lawful because you have a right to a direct payment, regardless of what commissioning arrangements local authorities have done. And there's just been a recent ombudsman's report, which I referred to last week, which a family was getting some respite care for early help. And they didn't like that service and said, well, we want a direct payment instead. And the local authority, Liverpool, said, no, this is early help. You can't get direct payments for that. And the ombudsman said, think again, of course you can. And you don't have to give a reason for wanting a direct payment. It's a statutory right, subject to certain conditions, and we'll look at those conditions in a minute. Yeah, and I've already mentioned that case. Yeah, oh, sorry, this is the case I was just talking about. This is a parent who complained to a local authority that a local authority commissioned early help was unsuitable for her son, and she said she wanted a direct payment to purchase something suitable. The local authority accepted her son was a disabled person, but said that he wasn't sufficiently disabled to warrant an assessment by the Disabled Children's Team, and that only if the Disabled Children's Team assessed somebody could you get a direct payment. It had these sort of 4 levels, which many local authorities do. And they said you only get assessed by the Disabled Children's Team if you're in level 4. He's not in level 4. Yes, he's a disabled child within the meaning of the Children Act, but because he's not level 4, we won't assess him under the Disabled Children's Team, and we won't give direct payments to people that aren't assessed by the Disabled Children's Team. So effectively, the local authority was refusing to comply with the law. It was creating its own mini sort of subverted version of the law. And the ombudsman didn't really have any difficulty in saying it's simply unlawful. Anything provided under the Children Act, and you're providing respite care, early help respite care under the Children Act, entitles the disabled person or their family to ask for a direct payment. Think again. Quite a big, important decision that's came out a couple of weeks ago. So the duty to make payments is when the person appears to be capable of managing it themselves or with such assistance as may be available to them. They consent to the making of direct payment, which means they've got to understand what the purpose is, as well as say they want it. And the local authorities is satisfied that the assessed need can be met by means of the direct payment. The presumption is it can be. So if the local authority says, no, you can't have a direct payment because we aren't satisfied, the local authority would have to explain, give reasons. The onus would be on the local authority to explain why that particular individual wouldn't use the money to meet their needs. And in the case of a child, the local authority has also got to be satisfied that the welfare of the child will be safeguarded and promoted by the use of the direct payment. But again, the presumption is it will be. So the local authority would have to then say, well, we won't do it to you because you have got a history of not using the money appropriately or whatever, something personal to that family. So the client group who can get direct payments is really any adult or child with a disability. If you're 16 or 17 with a physical or mental impairment or illness, the money can actually technically be paid to you. Although up to 18, it could also be paid to your parent. There's a choice there for 16 or 17-year-olds whether the direct payment is paid into the bank account of the child or the adults. There's some guidance on that, and I can explain how you decide if there's if the child wants it in, the young person wants it into their bank account and the parents don't agree. But normally that's not an issue. It can go into the bank account of a parent of a disabled child. It must if it's under 16, and there is this issue if they're 16 or 17, whether it goes into the disabled person's account or the parent's account. And carers who are eligible for care and support also have a right to have that care and support paid as a direct payment. So they're what I call direct payment persons, which is pretty well everybody that we're interested in social care. And that individual must have been assessed as eligible for support. So the local authority says, yes, you have this need for this, this, and this. And then the individual is offered a direct payment and they say, yeah, I'll have a direct payment, please. Then there's various, at that stage, the right is crystallized, but it can, but it's still subject to certain conditions. The first condition is that there are some people who simply are not allowed to have a direct payment for public policy reasons. This used to be quite a wide range of people, but now it is simply somebody who is on a drug treatment and alcohol order. So if you've got an addiction problem, you've got a substance misuse problem, you're a disabled person under law, and you could therefore, if you have needs relating to that, social care needs, you could have a direct payment. But if you have a criminal conviction, and that criminal conviction requires you to undergo regular drug treatment or testing, you're excluded. And that's the only group of people. So it's a very small group of people. You must be able to consent to the direct payment, and you must also be capable of managing it with assistance or alone or with assistance, or have an authorized person do it for you. Consenting means that you understand, you have the mental capacity to understand why you're getting the direct payment. You have sufficient mental capacity to decide that this direct payment is being given to you so that you can employ a personal assistant or pay for a particular item or service. There's a lot of guidance on that. And if it's paid to your parents or to an authorized person, then obviously that parent or authorized person must have the necessary capacity. The local authority has got to be satisfied that the need will be met. So if there's any evidence that the parent in the past hasn't used the money to buy the assessed need, but used it for some other purpose, then the local authority could say, well, we're not going to make a payment to you in this situation because you have a track record we have evidence of a problem. But if the local authority doesn't have any evidence about that particular individual, then it's not going to be able to refuse. And if there's a child, the direct payment must be, as I say, in the child's best interests, but the presumption is it will be. So again, the local authority would have to have some argument specific to the particular family that it's not. And once those things have happened, you're in the business, you have this right to demand a direct payment. At that stage, there are still some hurdles that you have to cross. There are some things that direct payments can't be used for, except for example. So there are really basically 4 hurdles that you have to jump. The first is that there are certain services you can't buy with a direct payment. They're very restricted, but basically they're long periods of residential care. So this applies particularly to older people who might have quite substantial needs, and they say, well, you need to go into a residential or nursing home, but it'd be true for a young person as well. If those periods of residential care are more than 4 weeks long in any 12-month period, then you can't have that period. So you're allowed up to 4 weeks in residential care in any 12-month period. That's actually more complicated than it sounds, because a week only counts as a qualifying week if it isn't separated by 2 or more weeks from another week, which, sorry, it gets technical, but the guidance says that where a period between the 2 stays is less than 4 weeks, then the 2 stays should be added together to make the total, which should also not exceed 4 weeks if it is paid as a direct payment. On the other hand, if 2 residential care stays are more than 4 weeks apart, then they are not added together. So what it's saying is, if I go into a care home for 2 weeks and then I come out for 2 weeks and then they go back in for 2 weeks, because those 2-week periods in the care home weren't separated by 4 weeks, they are aggregated. So I've had my quota for the year, my 4 weeks is hit. But if I go into a care home for 2 weeks and then I come out for 5 weeks and then go back in for 2 weeks, because those periods in residential care are separated by 5 weeks, more than 4 weeks, they're not aggregated. So I could do that for the whole year. I could go in for 2, out for 5, in for 2, out for 5, in for 2. So actually I could end up with, I don't know, 20 or 20 weeks or something like that as a direct payment. That's about as technical as this talk gets. I'm sorry, but normally that won't be a problem. But you can have regular stays of respite care and residential care as a direct payment. And you can't use your direct payment to buy a service that the local authority is actually providing itself. So if the local authority has a day centre or a respite care centre or something like that, that is actually staffed by people employed by the local authority, then you can't have a direct payment for that service. So there are very limited services you can't have direct payments for. By and large, the vast majority you can. There is an exclusion on who you can pay with your direct payment, and that largely is to do with family members. So there's a general rule against paying a direct payment to a spouse or your partner or any relative who lives in the same household. So there's no problem about paying a relative, employing a relative with a direct payment. The only problem is if they're living in the same household. And if the person you want to employ with the direct payment is a spouse or a partner or a relative living in the same household, there's a general presumption against using it, but you can if the local authority is satisfied that it's necessary. Now, many local authorities say you just can't use a direct payment to pay a family member, which is wrong. And some of them say, well, you can, but if they live in the same household, we can only do it in exceptional circumstances. And that's wrong too, because it's not exceptional, it's simply got to be necessary, which is a lower threshold. As I say there, being satisfied something's necessary is much lesser requirement than exceptional. There's many examples being given on this. This is a young person who was blind, deaf, and required constant supervision. There was a real need for continuity of carers. The direct payment was paid to her father to provide the care. He asked for more money, actually, for the direct payment, and the local authority responded by saying, well, we don't want you to have this arrangement any longer. And the local authority, the case went to the Ombudsman and said that that's just unlawful. The local authority accepted the father was best placed to provide the care and no rational reason for requiring it to be used for an alternative care. And I think, I mean, that guidance was very much emphasized in the COVID period, where it was particularly difficult for some families to get personal care assistance because of isolating and things like that. And so the government emphasized that one of the flexibilities would be to pay family members. But it's still true, I think, because of this reoccurring thing that I'm hearing from you and your colleagues, is the difficulty in getting suitably qualified care assistance. And in this case, you can see that continuity of care is as important sometimes as getting somebody with the skills. You might get somebody with skills, but they might leave because the rate is so low and they've been offered a more attractive post. So you need to pay a much higher rate, not only to get people with the relevant skills, but also to retain them. And if the local authority's rate is so poor that you can't attract or retain key people, and then if there is an option of having a family member, that could be suggested. Of course, the main answer would be for them to pay more money. Yeah, this is another case. A young adult with serious spinal injuries at hospital wanted, at the university wanted to employ his mother as a PA. She was a single mother. She gave up work to care for her son. The council refused, saying the test was exceptional circumstances, and the Ombudsman said that's not true. It's just simply, is it necessary? And the local authority just said, the Ombudsman said there was no evidence that council had looked at this properly. The amount of a direct payment, I think, is a crucial issue, which I think we can discuss after we break, and I'm coming towards the end of these slides, I hope. What I'm saying really there is that the amount of a direct payment isn't chiseled in terms of the stone. You can't have maximum. So local authorities can't say, we won't pay more than £12 an hour or something like that. The direct payment must be sufficient to enable the recipient to lawfully secure a service to the standard the local authority considers reasonable. And therefore the rate's got to be enough to attract, as I say, people with the appropriate skills, which might be applied behavioral analysis for somebody with learning disabilities, and also sufficient to retain them, particularly if continuity of care is important, which it nearly always is. You don't have a succession of different assistants coming in and out. And I think this is something which local groups, particularly parent care forums, will have to take up with councils, because this isn't just one family, it's nearly every family, it seems to me, is having this particular problem. Local authorities really trying to hold the rates down when all the evidence is showing that people are not able to employ personal assistants and retain them. And so you're having long periods of time where a direct payment's not being used because there just is nobody there to do it. And that's to do with the fact that the rate is too poor. But then the local authority will say, well, we want to recoup that money because you haven't spent it. You didn't spend it because the local authority set it at too low a figure. If you're an authorized person, so this is a disabled adult, but they lack the capacity to manage their direct payment. So the direct payment is being paid to somebody who's authorized to manage on their behalf. Then if that person says, well, I want a direct payment, which is their right, but I don't want to employ a personal assistant because it's too much of a hassle, the local authority, the Ombudsman has said that the local authority must pay the agency rate, not the personal assistance rate. So if I'm a disabled person and I say to the local authority, I don't want a direct payment, the local authority will provide me with personal assistant that they pay an agency. Now, of course, they will pay, let's say, £18 an hour or something like that to an agency, because they've not only got to pay for the employment of the individual, but they've got to pay the agency's overheads and their profits. Whereas if I employ an individual, I'm only going to get £12 an hour, or whatever the going rate is in your area. But if I'm an authorized person, I can say I don't want to employ a care assistant. I want to use the direct payment to pay an agency. And then the local authority should pay me the agency rate, not the local authority rate. That's what the Ombudsman held in the Cornish Ombudsman's case. And recipients of direct payments have got to keep records of how the money's been spent. But the guidance is very clear that this shouldn't be an arduous, disproportionately burdensome activity. And then you're in business. I'm not going to go through prepayment cards. There's been quite a lot of guidance on this. There's quite a lot of clashes on this. Some local authorities, instead of giving you money into your account, are giving you a card, which is a bit like a credit card with a fixed amount in it that you can only use for certain activities, which they heavily monitor because it's their card, so they get all the records. There's been a lot of challenges that, and the Ombudsman's been quite clear that, and the guidance is quite clear, that people can have a traditional direct payment card if they so choose. So I'm going to motor through that fairly quickly. You'll have that how. And again, some local authorities are being very rigid about what you can spend your direct payment on. Direct payments do not have to be used in the same way as if support was being provided directly by the local authority. Indeed, they're intended to give the individual the maximum degree of choice and control over how their needs are met. And there's some guidance from the National Institute of Clinical and Healthcare Excellence, Care and Healthcare Excellence, that says that the care payments should be flexible to accommodate changes to a person's priority, needs and preferences. And in order to facilitate this, local authorities should consider agreeing a rolling 3-month budget so that people can use their money differently each week. Well, that is in many parts of England not happening. Local authorities, if somebody tries to use the direct payment in a slightly different way, then the local authority is saying, no, that was an inappropriate payment, we wanted money back. And these are some cases on flexible use. The Ombudsman tried to stop somebody making direct payments for horse riding and other activities to meet an identified eligible need. The local authority had given no good reason why horse riding, because it was quite a wide definition. In this case, the person needed sort of activities out of the house during the day, and the Ombudsman thought that that came within the horse riding came within that definition. And the Ombudsman cited the statutory guidance, direct payments are designed to be used flexibly and innovatively, and there should be no unreasonable restriction placed on their use of the payment as long as its use is to meet an eligible care and support need. The council told that Mrs. X's unused social support hours could not be used at a later date. The council said that the Ombudsman said this isn't helpful. It's not person-centred and it's contrary to the guidance. This is quite a long decision, and again, I'm not going to go through it because I'm coming toward the end of my time. But it's something I'd quite like to discuss. Is if you have a direct payment and the rates are so low, you can't spend it all, or if because of COVID you couldn't spend it all, you will have accumulated a surplus, and the council will say we want the money back, and you haven't been using it for, you know, the 5 hours you were allocated each day or each week, and therefore we want it back because that's water under the bridge, it's gone. And I think there's a very strong argument for saying, because I didn't use it, I am suffering much more stress and anxiety. I need a much bigger break. I need to carry that money forward and use it in a slightly different way, innovatively, in a different way. And I think I've got a case. And often also, well, this is a case there where the accumulated surplus comes because the council really hasn't told the person it has to be used in this way or that way, or that you can't carry surpluses forward. So this is somebody who had accumulated money because of it had been underspent, but the local authority had failed to undertake annual reviews or communicate with the adult for 4 years. And the Ombudsman said, I can't see how she could have known she wasn't managing her direct payment account properly. I therefore don't consider that gave her the opportunity to amend spending or to correct the situation by keeping records. So if the local authority wants to criticize somebody, they've got to really demonstrate that they told them that in the first place. And the final bullet point there I think is important, is if local authorities are really requiring wage slips to be kept for everything, payments for everything, you know, when it's quite clear that the service has been bought, that the service has been provided, but the person just can't provide the actual slip, that's becoming overly onerous. It's not the light touch that the government guidance talks about. Yeah, this is one of the few Ombudsman's cases that sort of touching on the point that I'm interested in. This was a very substantial package paid as a direct payment. And during the COVID period, a very substantial amount of surplus was accumulated. And the person that was managing this for the adult, so this is an adult who lacks capacity, so I think it was his mother, she was the authorized person, and she said, look, I'd like to use this surplus to put a garden room out in the garden. And I think that the direct payment was basically to buy respite care, replacement care for her, so she could have a break. And the Ombudsman and the local authority said, well, you can't do that. We want the money back because we haven't assessed you as needing a garden room. And the mother basically said, but a garden room would give me respite care. He would, you know, I think he had autistic spectrum disorder where he needed space. He needed in the garden, it was a secure garden, that he would be able to go there and that would give her space in the house. They wouldn't be under each other's feet. And therefore, there's a viable argument to say that, but using the money for a garden room would give her that replacement care, that sense of well-being, of space. And the local authority just said no. And the Ombudsman noted that this needed to be addressed through a discussion between the family and the council, but that the way the council dealt with spending surplus budget on a garden room does not assist with building a positive working relationship. So the local authority should have engaged in that discussion. I think the surplus was 12,000, something like that. And I think that's really useful. I think that in saying, well, look, what I'm trying to do may sound to you very different to what the assessed need was, but in fact, it would give me that break. And I need that break even more because I've had 3 months or 6 months without any break, and I'm almost suffering sort of breakdown. Just on this issue of inadequate personal assistance under the Care Act, this is for relating to adults, but it must be true, I think, implicitly for young people. Under the Care Act, there's an explicit duty on local authorities to manage the marketplace, to ensure that there is an adequate supply of care and support, which will include an adequate supply of personal assistance, individually and private organizations, care providers, to ensure that, among other things, there's a variety of providers, services to choose from, high quality services to choose from. And I think that particularly for adults, you can use that, but in relation to if you're an organization, if you're a forum, a parent care forum, in relation to children, it must be equally important for the children's services to ensure that the market is operating. And of course, there's a complete market failure in relation to personal assistance at the moment. And if a family says, look, we can't use our direct payment because there really are no personal assistance, so we don't want it, we want you to go and sort that out yourselves. The Ombudsman said that generally a local authority must, within 2 weeks of the assessed need being identified, ensure that support is put in. And what we've said on the last occasion, that when local authority puts support in, it commissions providers, it's got to have a plan B, a contingency plan for what happens if the care assistant doesn't turn up or is ill or whatever. There's got to be backup. And that seems to me the big problem is that you might get one personal assistant, but if that personal assistant is unavailable for any reason, there is nothing left. There are no reserves. There's nobody on the substitutes bench. This is quite an old decision, but I think it's an important one. Because of a recruitment problem, an agency withdrew providing weekend support for an adult. And the council couldn't find another agency willing to provide this service at the weekend, except one agency did offer to do it, but said we would require an additional sum over the flat fee, which is for travel, because they're saying our personal assistant would have to travel 15 miles or something. So we you know, you can pay us your standard rate, but you must also pay us the mileage rate. And the council said, no, we're not going to do that because we've got this policy and we can't break this policy because that would cause huge sort of ramifications. We don't pay travel costs for carers or whatever. And the Ombudsman said this, it cannot be easy to arrange for home care. This was a rural part of, this was Essex. It cannot be easy to arrange for home care in the rural parts of the county's area. And even the best contractual agreements must fail from time to time. But it seems to me that when a service failure occurs, the council might well have to seize any realistic opportunity to make the service good. Here it had such an opportunity. Another home care contractor offered to provide the care, but only if the council would pay the costs over and above the flat fee, when it was a small sum. Doubtless there are many tussles between the council and its providers over such arrangements, and I can well understand why the council might have considered this a precedent, the thin end of the wedge. but what was that to the adult? Seems to me that his home care was entirely sacrificed to maintain the purity of the council's contractual arrangement. This was a classic sense of the council fettering its discretion, and it was unlawful. Right, sorry, I've rattled through that, colleagues.